Hello, my name is Professor Shiladitya Rakshit. Module Custodial Justice Learning Outcomes. To give students an understanding of the role played by the process of public investigation in India in the origin, evolution, and development of prisoners' rights. By the end of the lecture, students will have an understanding of the human rights of the prisoners and role played by the Supreme Court in recognizing these rights. Introduction: Prisoners and the Human Rights. PIL activism has brought to the notice of the Supreme Court incidents of human rights violations by custodial institutions such as prisons, mental asylums, and women's homes. Incidents of police brutalities and encounter killings have also attracted remedial attention. The Supreme Court of India in the recent past has been very vigilant against encroachments upon the human rights of the prisoners. In this area, an attempt is made to explain that some of the provisions of the rights of prisoners under the international and national arenas, and also as interpreted by the Supreme Court of India by invoking the fundamental rights, Article 21 of the Constitution of India, provide that no person shall be deprived of his life and personal liberty except according to procedure established by law. The right to life and personal liberty is the backbone of the human rights in India. Through the positive approach and activism, the Indian judiciary has served as an institution for providing effective remedy against the violations of human rights by giving a liberal and comprehensive meaning to life and personal liberty. The courts have formulated and have established a plethora of rights. The court gave a concrete meaning to the fundamental rights enshrined in Article 21. One of the most powerful dimensions that arose through public investigation is the human rights of the prisoners. The Supreme Court of India has considerably widened the scope of Article 21 and has held that its protection will be available for safeguarding the fundamental rights of the prisoners and for effecting prison reforms. The Supreme Court, by its progressive interpretation, made Article 21, which guarantees the right to life and personal liberty, the reservoir of prisoners' rights. Under the 7th schedule of the Constitution of India, the prisoner administration, police, and law and order are to be administered by the respective states. The states have generally given low priority to prison administration. In fact, some of the decisions of the Supreme Court of prison administration have served as eye-openers for the administration and directed the state to modernize prison administration. In D.K. Basu versus State of West Bengal, the Supreme Court acted upon a letter petition in August 1986 by the chairman of the Legal Aid Services, West Bengal, which referred to the increasing incidence of custodial death in West Bengal. The court issued extensive directions to be followed by the police upon the arrest of a person and the minimum facilities available to such person. The court observed police is no doubt under a legal duty and has a legitimate right to arrest a criminal and to interrogate him and during the investigation of such an offence, but the law does not permit use of third-degree methods or torture of the accused in custody during interrogation and investigation with a view to solve the crime. The court ruled that a relative of the arrested person must be promptly notified and that the court stations must be prominently display the basic rights available to a detainee. There are a few instances of denial of human rights where the only way to protect human rights has been to grant compensation. The compensation jurisprudence was most clearly articulated by the Supreme Court in 1993 in Nilabati Behera versus State of Orissa in response to a PIL alleging death of a boy of 22 years in police custody. The court evolved the principle of public law doctrine of compensation for violation of human rights. According to this doctrine, liability of the state for violation of human rights is absolute and admits of no exception such as sovereign immunity. In this case, the court awarded rupees 1,50,000 to the mother of the boy as compensation for custodial death. In D.K. Basu, the Supreme Court has articulated compensation jurisprudence. Thus, award of compensation for established infringement of indivisible rights guaranteed under Article 21 is a remedy available in public law, since the purpose of public law is not only to civilize public power but also to ensure that citizens that they live under a legal system wherein their rights and interests shall be protected and preserved. Compensation jurisprudence for custodial violence is a positive achievement of PIL, but compensation award appears to be arbitrary and look more like a charity. The court has not laid down the criteria or yardsticks to measure the amount of compensation to be given for violation of human rights. Then there is little evidence that the guilty officials have actually been punished, even in those cases where the prosecution has been launched. The case remained pending for years in the absence of judicial monitoring of proceedings. Rights against solitary confinement and bar fetters. The courts have taken a strong view against solitary confinement and held that imposition of solitary confinement is highly degrading and has a dehumanizing effect on the prisoners. The courts have taken the view that it could be imposed only in exceptional cases where the convict was of such a dangerous character that he must be segregated from the other prisoners. The Supreme Court in Sunil Batra 1 considered the constitutional validity of solitary confinement prescribed under Section 30, Clause 2 of the Prisons Act 1894. Section 30, Clause 2 of the Act provides the solitary confinement when prisoner is under sentence of death, while Section 56 of the said Act permits the use of bar fetters for the safe custody of the prisoners. The Supreme Court, while approving Section 30, Clause 2 of the Prisoners Act 1894, declared that imposition of solitary confinement on Sunil Batra was illegal on the ground under sentence of death refers to a finally executable death sentence, which means that the sentence of death has become final and conclusive and cannot be annulled by any judicial or constitutional authority. The court held that Batra was put in statutory confinement and not solitary confinement. The Supreme Court has also reacted strongly against putting bar fetters to the prisoners. The court observed that continuously keeping a prisoner in fetters day and night reduced the prisoners from human being to an animal, and such treatment amounted to cruel and unusual punishment. The Apex Court declared that bar fetters can be used subject to the following procedural safeguards. A. It must be absolutely necessary to use fetters. B. The reasons for doing so must be recorded. C. The basic conditions of dangerousness must be well grounded. And D. Principles of natural justice must be observed. And E. The fetters must be removed at the earliest possible opportunity. And F. There must be a daily review for the absolute need for bar fetters. G. Continuance of bar fetters beyond a day is subject to the direction of a district magistrate or sessions judge. The Supreme Court in Sunil Batra 1. Diluted the rigor of solitary confinement and bar fetters to a considerable extent by specifying the procedural norms to be followed when resorting to Section 30 Clause 2 and 56 of the Prisons Act 1894. Rights against handcuffing. In Prem Shankar v. Delhi Administration, the Supreme Court added yet another projectile in its armory to be used against the war for prison reform and prisoners' rights. In this case, the Supreme Court discussed the constitutionality of the handcuffing. It is a case placed before the court by way of a public interest litigation, urging the court to pronounce upon the constitutional validity of the handcuffing culture in the light of Article 21 of the Constitution. In the instant case, the court banned the routine handcuffing of a prisoner as a constitutional mandate and declared the distinction between classes of prisoners as obsolete. The court also opined that handcuffing is prima facie inhuman and therefore unreasonable, is over harsh, and at the first flush arbitrary. Absent fair procedure and objective monitoring to inflict irons is a resort to zoological strategies repugnant to Article 21 of the Constitution. While deciding the constitutionality of handcuffing, the Supreme Court specifically referred to Article 5 of the Universal Declaration of Human Rights 1948 and Article 1G of the International Covenant on Civil and Political Rights and held that handcuffing is impermissible torture and is violative of Article 21. In spite of such clear ruling of the Supreme Court against handcuffing, the high-handedness of the police personnel came to light in Delhi Judicial Service Association case, wherein the Supreme Court held that an extraordinary and unusual behavior of police was not proper, and the court laid down detailed guidelines which should be followed in case of arrest and detention of judicial officer. The Supreme Court took a serious note of the whole incident, and it amounts to interference with the administration of justice, lowering of a judicial authority, and amounts to criminal contempt. It is submitted that whenever any police official acts contrary to the clear directions against handcuffing as laid down the Supreme Court and thus violates the basic human rights to human dignity, he should be made personally liable to pay the compensation, and this fact is clearly established in State of Maharashtra versus Ravikant S. Patil. The Supreme Court directed the Union of India to frame rules or guidelines regarding the circumstances in which handcuffing of the accused could be resorted to in conformity with the judgment of the court in Prem Shankar case, and to circulate them amongst all the governments of the state and union territories for strict observance. It is important to mention that so as to put an end to handcuffing, it is suggested that the Parliament may make a suitable amendment in the Indian Penal Code 1860 and the Code of Criminal Procedure 1973, wherein handcuffing should be made a cognizable offence so as to give effect to the ruling of the apex court of the land and also to preserve the right to live with human dignity, which is an important facet of personal liability of the individuals. Rights against inhuman treatment of prisoners. Human rights are part and parcel of human dignity. The Supreme Court of India, in various cases, has taken a serious note of the inhuman treatment on prisoners and issued appropriate directions to prison and police authorities for safeguarding the rights of the prisoners and persons in police lockup. The Supreme Court read the right against torture into Articles 14 and 19 of the Constitution. The court observed that the treatment of a human being which offends human dignity imposes avoidable torture and reduces the man to the level of a beast would certainly be arbitrary and can be questioned under Article 14. In the Raghubir Singh versus State of Bihar, the Supreme Court expressed its anguish over police torture by upholding the life sentence awarded to a police officer responsible for the death of a suspect due to torture in a police lockup. In Kishore Singh versus State of Rajasthan, the Supreme Court held that the use of third-degree method by police is violative of Article 21. The court also directed the government to take necessary steps to educate the police so as to inculcate respect for the human person. In that case, the Supreme Court brought home the deep concern for human rights by observing against police cruelty in the following words: "Nothing is more cowardly and unconscionable than a person in police custody being beaten up, and nothing inflicts a deeper wound on our constitutional culture than a state official running berserk regardless of human rights." It is pertinent to mention that the custodial death in perhaps one of the worst crimes in civilized society governed by the rule of law. The court promptly ruled that the inhuman treatment meted to the accused in police custody is the gross and blatant violation of human rights. In the absence of any legislative or executive guidelines, the court has undertaken an activist role and ruled in plethora of cases, and one such case is D.K. Basu versus State of West Bengal. The decision of the Supreme Court in the case of D.K. Basu is noteworthy. While dealing the case, the court specifically concentrated on the problem of custodial torture and issued a number of directions to eradicate this evil for better protection and promotion of human rights. In that case, the Supreme Court defined torture and analyzed its implications. With a view to curbing the menace, the Supreme Court laid down detailed guidelines as preventive measures of torture. The apex court made it clear that custodial violence, including torture and death in the police lockup, strikes a blow at the rule of law, which demands that the powers of the executive should not only be deprived from the law, but also that the same should be limited by the law. The court also made it clear that failure to comply with guidelines should, apart from rendering the critical concern liable for departmental action, and also render him liable to contempt of court. The Supreme Court has made it clear beyond doubt that any form of torture, of cruel, inhuman, or degrading treatment is offensive to human dignity and is violative of Article 21 of the Constitution. 6. Right to have interview with friends, relatives, and lawyers. The horizon of human rights is expanding. Prisoners' rights have been recognized not only to protect them from physical discomfort or torture in prison, but also to save them from mental torture. The right to have interview with the members of one's family and their friends is clearly part of the personal liberty embodied in Article 21. Article 22(1) of the Constitution directs that no person who is arrested shall be denied of the right to consult and to be defended by a legal practitioner of his choice. This legal right is also available in the Code of Criminal Procedure under Section 304. The court has held that from the time of arrest, the right accrues to the arrested person and he has the right of choice of a lawyer. The accused may refuse to take a lawyer, but the court has to provide an amicus curiae to defend him. In a series of cases, the Supreme Court of India considered the scope of the right of the prisoners or detainees to have interviews with family members, friends, and counsel. In Francis Correll Mullin vs. Administration, Union Territory of Delhi, the Supreme Court considered the prisoner's right to have interviews from the perspective of the right to life and personal liberty under Article 21. In this case, the court also opined the right to have interview clearly part of personal liberty, and that personal liberty would include the right to socialize with members of family and friends subject to any valid prison regulations. Therefore, any prison regulation or procedure regulation, the prisoner's right to have interviews with the members of a family and friends must be reasonable and non-arbitrary. Otherwise, it would be liable to be struck down as invalid, being violative of Articles 14 and 21. From the above analysis, it firmly leads to the conclusion the right of the prisoners to have interview with friends and family members is an integral part of Article 21 of the Constitution. In Joginder Kumar vs. State of UP, the court opined that the horizon of human rights is expanded and at the same time the crime rate is also increasing, and the court has been receiving complaints about violation of human rights because of indiscriminate arrests. The court observed that there is the right to have someone informed, that the right of the arrested person upon request to have someone informed and to consult privately with a lawyer was recognized by Section 56 Clause 1 of the Police and Criminal Evidence Act 1984 in England. Right to legal aid. The main object of the free legal aid scheme is to provide means by which the principle of equality before law, on which the edifice of our legal system is based, is also means financial aid provided to a person in matter of legal dispute in the absence of free legal aid to the poor and needy. Fundamental rights and human freedoms guaranteed by the respective constitution and international human rights covenants have no value. However, the Constitution of India does not expressly provide the right to legal aid, but the judiciary has shown its consideration towards poor prisoners because of their poverty and is not in a position to engage the lawyer of their own choice. The 42nd Amendment Act 1976 has included free legal aid as one of the directive principles of state policy under Article 39A in the Constitution. This is the most important and the direct article of the Constitution which speaks of free legal aid. The Parliament has enacted Legal Service Authorities Act 1987, under which legal aid is guaranteed, and various state governments had established legal aid and advice board and frame schemes for free legal aid and incidental matters to give effect to the constitutional mandate of Article 39A. In Husainara Khatun and others versus Home Secretary, State of Bihar, the main observations of the Supreme Court are on a speedy trial. In this case, the Apex Court declared the speedy trial as a constituent of legal aid and directed the government to provide free legal aid service in deserving cases. This case reinforced the principles, and down in M.S. Hoskote's case, Justice Bhagwati observed that Article 39A of the Constitution also emphasized that free legal service is an unalienable component of reasonable, fair, and just procedure, for without it, if a person suffered from economic or other disabilities, would be deprived of the opportunity for securing justice. The right to free legal service is therefore clearly an essential ingredient of reasonable, fair, and just procedure for a person accused of an offence, and must be held implicit in Article 21 of the Constitution. In Sunil Batra versus Delhi Administration 2, Justice Krishna Iyer observed that the free legal services to the prison programs shall be promoted by professional organization. Recognized by the court, the further added that District Bar Association should keep a cell for prisoner relief. In Khatri 1 versus State of Bihar, a division bench of the Supreme Court held that the state is under constitutional mandate to provide free legal aid to an accused person who is unable to secure legal services on account of indulgence, and whatever is necessary for this purpose has to be done by the state. Right to speedy trial. The speedy trial of offences is one of the basic objectives of the criminal justice delivery system. Everyone is presumed to be innocent until the guilty is proved. So the quality of innocence of the accused has to be determined as quickly as possible. It is therefore incumbent on the court to see that no guilty person escapes. It is still more its duty to see that justice is not delayed and the accused persons are not indefinitely harassed. It is pertinent to mention that delay in trial by itself constitutes denial of justice, which is said to be justice delayed is justice denied. The right to speedy trial has become a universally recognized human right. Taking the principles of fairness and reasonableness evolved in Maneka Gandhi's case, the Supreme Court in the Husainara Khatun 1 versus Home Secretary case held that obviously procedure prescribed by law for depriving a person of his liberty cannot be reasonable, fair, or just unless that procedure ensures a speedy trial for determination of the guilt of such person. No procedure which does not ensure a reasonably quick trial can be regarded as reasonable, fair, or just, and would fall foul of Article 21. There can be no doubt that speedy trial, and by speedy trial we mean reasonably expeditious trial, is an integral and essential part of the fundamental right to life and liberty enshrined in Article 21. Thus, the right to speedy trial is implicit in broad sweep and context of Article 21 of the Constitution. Hence, any accused who is denied the right to speedy trial is entitled to approach the Supreme Court for the purpose of enforcing such rights. However, the main procedure for investigating and trial of an offence with regard to speedy trial is contained in the Code of Criminal Procedure. The right to speedy trial is contained under Section 309 of CRPC. In A.R. Anatule versus R.S. Naik, the Supreme Court has laid down following proposition which will go a long way to protect the human rights of the prisoners. The concerns underlying the right to speedy trial from the point of view of the accused are a. The period of remand and pre-conviction detention should be as short as possible. In other words, the accused shall not be subjected to unnecessary or unduly long detention point of his conviction. And b. The worry, anxiety, and expense and disturbance to his violation and peace resulting from an unduly prolonged investigation, inquiry, or trial shall be minimal, and c. Undue delay may result in impairment of the ability of the accused to defend himself, whether on account of death, disappearance, or non-availability of witnesses, or otherwise. In the instant case, the apex court held the right to speedy trial following from Article 21 of the Constitution is available to the accused at all stages like investigation, inquiry, trial, appeal, revision, and retrial. The court said the accused cannot be denied the right to speedy trial merely on the ground that he had failed to demand a speedy trial from the above cases and principles of the Supreme Court. It can be concluded that the right to speedy trial that is implicit under Article 21 of the Constitution. In these words of Justice Bhagwati, that it is the constitutional obligation of the state to provide a procedure which would ensure speedy trial to the accused. Right to say no to narcoanalysis, polygraph brain mapping. In Selvi v. State of Karnataka, the Supreme Court has declared narcoanalysis, polygraph tests, and brain mapping are unconstitutional and violative of human rights. The decision is quite unfavorable to various investigation authorities, as it will be a hindrance to the furtherance of investigation and may allege criminals will escape conviction with this new position. But the apex court further said that a person can only be subjected to such tests when he or she assents to them. The result of tests will not be admissible as evidence in the court, but can be used for furtherance of investigation. With advancement in technology coupled with neurology, narcoanalysis, polygraph test, and brain mapping emerged as favorite tools of investigation agencies. Argued that the word for eliciting a truth from the accused, but eventually voices of dissent were heard from human rights organizations and people subjected to such tests. They were labeled as atrocity to human mind and breach of right to privacy of an individual. The Supreme Court accepted that the tests in questions are violative of Article 20, Clause 3, which laid down that a person cannot be forced to other evidence against himself. Court also directed the investigation agencies that the directives by the National Human Rights Commission should be adhered to strictly while conducting the tests. These tests were put to use in many cases previously. The Arushi Talwar murder case, the Nithari killings cases, the Abdul Telgi case, the Abu Salem case, the Pragya Thakur bomb blast case, etc., being ones which generated a lot of public interest. Conclusion. To conclude, a review of the decisions of the Indian judiciary regarding the protection of human rights of prisoners indicates that the judiciary has been playing a role of savior in situations where the executive and legislature have failed to address the problems of the people. The Supreme Court has come forward to take corrective measures and to provide necessary directions to the executive and legislature. From the perusal of the above contribution, it is evident that the Indian judiciary has been very sensitive and alive to the protection of the human rights of the people. It has, through judicial activism, forged new tools and devised new remedies for the purpose of vindicating the most precious of the precious human rights to life and personal liberty. Thank you.